Today, we're going to cover the 5 estate planning mistakes that retirees make that can destroy a lifetime of savings. Let's not do that. Attorney Liz Nolin, can we help the people out today?
We sure can, Mike. Thanks so much for having me.
It's a pleasure to have you two here. We're going to jump right into it and get into mistake number 1, which is assuming a will avoids probate.
Yes, that's a very common mistake. Wills do not avoid probate. What a will is exactly what it sounds like. It's your expression of your last will and desire of where assets go when you pass away. But if your only testamentary document, meaning a document you've got that's going to take over to after you die to dispose of all of your assets, if all you have is a will, everything you own in your personal name, asterisk, there's some assets that won't go through probate, but most of the big ones will go through the probate process.
But why? I mean, I've got a will. It says, my car goes to this person and my bank account goes to this other person. Why does that need to go through court?
Because the court is very interested in making sure that all of your creditors are paid off, for example. There's a lot of reasons the court gets involved. They need to make sure that an estate is administered correctly before any rest, remainder, and residue is distributed out to beneficiaries that are listed in the will. The court is a body of equity. We need to make sure everything is pretty fair. So when anything goes through probate, the court is immediately interested in, can we make sure that creditors are notified of the death, paid off, any outstanding taxes are satisfied, and then only when that has happened will the judge overseeing the probate case allow the other assets to be distributed out to the beneficiaries named.
So if I want to keep my family out of court, I'm going to need to do some more advanced estate planning.
Generally, yes. One of the best ways that we can help clients avoid going through the full probate process is by creating trusts. The way I explain trust to clients, our trusts are living, breathing entities, and probate is only for the realm of the dead. So if you create a trust and you properly put your assets that you're allowed to by law into that trust, when you die, the trust will continue to live on. And it's this living, breathing body that still owns the assets and can make distributions. If everything you've got is in properly titled trusts, there should be nothing for a probate court to deal with because you're not dying with any probate assets. They're assets that are literally owned and held within this living, breathing entity body that will survive you for as long as there are assets and beneficiaries.
Liz, thank you for breaking that down. Let's go into our second mistake, which is having outdated beneficiaries.
Yes, the outdated beneficiaries issue hits people who have very good estate plans and no estate plans and everything in the middle. Having outdated beneficiaries means that for some of your biggest assets, things like your retirement accounts, maybe some annuities, insurance policies, all of the remainders of those accounts will be shot out to the people that you've listed on there as the beneficiaries. If those are outdated, that means your money is going to go to people that you didn't intend it to go to. So making sure that your beneficiaries are always aligned with what you actually want is really important.
I've heard too that outdated beneficiaries can be problematic because your beneficiary designations trump anything else that you've done in your estate plan, such as will designations or trust designations. So if I have, say, like an old girlfriend or something down as my beneficiary, then my actual wife and kids might be shortchanged on a particular account or transaction. Is that accurate?
That is accurate. That's entirely accurate because some of your biggest assets are not able to be transferred into trust. So even when I've got clients who have fantastic trust estate plans, their beneficiary designations need to align to what that actual plan is. If you're still using your ex-girlfriend as your beneficiary, that is not a trust asset. It bypasses the probate process. Your ex-girlfriend would get a really nice surprise with that very large check in the mail after your passing. But unfortunately, your wife probably wouldn't be too happy about that.
I better double check those beneficiaries, Liz.
I'd recommend it.
All right, stick with us. We get 3 more to go with the biggest coming just up here. So stick with us. Number 3, we're going to get into, Liz, which is the mistake not coordinating accounts with your estate plan. What does that even mean?
Exactly. So I kind of alluded to it in our last point that we always want your beneficiary designations, your accounts to be in alignment with the actual estate plan that you're creating. We need everything to be going according to this master plan, or something might slip through the cracks. So one thing that is a very central focus of my practice is when clients do make trusts, getting their assets properly into the trust so that the trust actually handles the disposition of that asset. So in other words, doing things like taking your car from your personal name, retitling and re-registering into the name of the trust. A trust is an entity, and all it can do is govern the assets that are on purpose put into that entity. If you have something in your personal name at the time you die, that very well may go through probate, even though your trust is going to handle everything else. The process of getting your assets from your personal name into the name of the trust, we colloquially call that trust funding. And that process is very different for every class of asset, but we want to make sure that everything we can get into a trust gets in there. But again, some of your biggest items aren't ever going to go into your trust. So we want to make sure for most of our clients that the trust is listed somewhere as a beneficiary on things like 401ks, IRAs, insurance policies, so that after you pass away, the trustee has the right to collect all of the residue and distribute it out to your intended beneficiaries.
Yeah, I got to say, as a planner, I see this all the time. Someone will visit the office, will describe what kind of planning work they've done up until this point, and they'll say, I have a trust. And one of our first questions is, well, what's in it? And that causes a lot of confusion. People don't, what do you mean? The trust protects everything, right? As you just said, your assets have to point to the trust. You have to register your car or your home into the name of the trust. So that means retitling things. Yes. Or if it's a financial account like an IRA, you might have to elect to have the trust be a beneficiary of the account. The trust doesn't just step in automatically. It needs to be assigned to things. And people tend to be shocked because they spend a lot of time with an attorney. They sometimes spend a lot of money setting this all up, but they don't bring things into the end zone, so to speak, and have the trust actually mechanically apply any protection. So it's crazy that people will take that halfway, but it's so important that we're bringing this up.
Exactly.
So they can avoid it. Let's continue on and get into mistake number 4, everybody's favorite topic, Liz. As we get older, we might have health issues and we might be running alongside like either the Medicare or the Medicaid system. And you wanted to talk a little bit about the risks of ignoring long-term care.
We do know in 2026 that medical expenses toward the end of life are one of the biggest financial burdens that people face. Those often can be unexpected events that cost hundreds of thousands, if not on occasion, millions of dollars.
The costs are exploding too since COVID.
Exactly. Yeah. And so the lack of planning for long-term medical care is really something that can be very detrimental even to the best estate plan, because an estate plan is only going to work if there's something left in the actual estate. If it's bled dry during a person's life, then it implies, of course, that there's nothing to distribute after they've passed away because it's all been spent in these medical events. So I think one of the biggest mistakes retirees can make is not planning for the potential of long-term medical events happening. I am a very big proponent of long-term medical insurance when people can qualify, can afford it. That is its own system that you and the rest of the Arcadia team are very fluent with. I think it's a great idea to have that. It's a fantastic insurance policy and can really alleviate not only draining estates, but the fear and concern that it causes, usually in children, of how are we going to pay for mom or dad's care. It can usually be satisfied through a really good policy.
Well, Liz, let's stop for a second because I appreciate that you're mentioning that there's a financial planning element to this, but I think there's an even deeper level in the estate planning arena here. When we talk about ignoring, say, long-term care risks, on one level, if we have a medical event that costs a lot of money, it can be financially disruptive, but it can also be a disruption to the family itself. There's a person that's ill right? And what does their freedom look like? What does their autonomy look like? You can't ignore those issues. In your world, we're talking about healthcare proxies,
Yes.
power of attorney. Can you speak a little bit to some of the elements of a good estate plan that sometimes people overlook related to this issue?
Absolutely. Usually clients think estate planning deals almost exclusively with wills and or trusts, but there's a lot of lifetime documents that go into estate planning. When I do medical documents for clients as a part of their estate plan, I do 4 separate medical documents. I do their primary healthcare directives that come into effect generally when they've lost capacity and they're no longer legally able to make their own medical decisions for themselves. It's critically important that clients have listed down who their medical agents will be when they can no longer make their own decisions. I also like to take it a step further, where my clients articulate when they want medical treatment, but also clear end dates of when they want that to stop. Because asking an agent who usually is someone who you really love and loves you right back, asking them to make all the decisions on your behalf is a huge ask. So getting that all in writing is the first step. Then I like to supplement it with advanced dementia directives in case someone is afflicted with dementia and or Alzheimer's. It supplements the primary medical documents to give more specific direction with things like, if you've lost complete capacity, you've got dementia, when do you want assisted feedings to begin or end? When do you want feeding tubes or IV fluids? Would you prefer institutional placement or to stay at home as long as possible? Then I do separate HIPAA waivers, giving the named agents the right to see and disclose personally identifiable medical documents and speak to my clients' doctors. That's important to have not only when you've lost capacity. You could be dizzy, you could be sick just with a common cold and need somebody to be able to communicate with your medical team on your behalf. And especially as clients get older, really important to bring the family into the fold. And then the very last document I wrap it up with the morbid bow of the final disposition. After you have passed away, what's next? What are your post-death instructions, if any?
You're calling it morbid, and that's understandable, but to the same extent, like, to not address these issues in advance leaves so much more to chance and can really affect people at a distinctly vulnerable place in their lives, particularly if they're alive and dealing with a medical issue. And what I'm picking on kind of leads into the 5th and final mistake here, which is just not communicating about this stuff with family.
Yes.
I don't think, Liz, that you can just create a plan and have all these directives without electing a cast of characters, whether it be the trustee or your proxies, who are going to need to be involved. And a lot of times people don't even know what role they're going to play or what responsibilities they're going to have until they're thrust right into the spotlight, so to speak.
Yes.
So when we say this, the mistake is not communicating well, how do we unpack that and what should people be doing differently?
This is a very interesting topic because it rides the line of how much information are you comfortable giving people versus how much do they really need to know? So I work with a lot of clients who don't want their families to necessarily know how much money they've got, but we can still talk to their families about who they've picked as their successor trustee of the trust, just so we can give that person or those people the heads up of, you're going to have some administrative work to do after this person passes away. But especially with lifetime documents, particularly the medical ones, I always give my clients the advice of, after you have signed these documents, email PDF versions of your documents to your named medical agents now. We all generally have our cell phones attached to our hands. So if an emergency were to arise that, God forbid, a parent goes into a hospital, their child will have those medical documents right on their phone available, and they can go immediately to the hospital, forward the documents to the nurse's desk where they're going. The nurses will be happy to print it out for you. And then you don't have to swing by the house to try and find these original documents. Yeah. Communication is really key. And that can be limited. It doesn't mean you have to open up the books and tell everybody what your net worth is. But it really just means they know that you have a plan. They know where to find the plan. And I also really like meeting with my clients' kids, particularly in advance, because then they know me. So when the worst happens, they've already met me at a time that was good, and they're more likely to call me because they're familiar with me, with my process, and they feel more confident that I can help them.
Yeah, these are great points. I think so much of this is generational where, you go back, to say the greatest generation, you're going to know what you need to know when you need to know it
Yes.
was kind of the approach that everybody took. And today that just causes so much anxiety. It causes so much problems. Like people will say like, listen, mom, dad, I don't mind helping you out, but don't just thrust me in the middle of a meat grinder. Like
Exactly.
appreciate that I have my own problems. I have like my own demands on my time. I want to be involved because I think most people want to help. And to your point, that doesn't mean you have to reveal everything about your personal finances. There's ways of maintaining discretion, but just having an open and honest conversation with family members about expectations and responsibilities is huge because a lot of times this stuff is work. It can be stressful. There can be a lot going on when the what hits the fan. So making sure that everybody is in the know and understands what's like required of them, I just think solves a lot of problems well in advance.
It really does.
Liz, thank you for helping us unpack this today, going through the 5 mistakes. If you're interested in learning more, check out our next video about the 5 estate planning myths, and we'll see you next time on Saturday State of Mind.